Hello and welcome to a special edition of The Big Picture. We are here in Bangalore today at Suchitra Film Society, an iconic cultural center. Today we are looking at the issue of Cauvery, the Cauvery river water issue, which has been a problem between Karnataka and Tamil Nadu for decades. In fact, sharing of river water is something which has been bothering not just the two states of Karnataka and Tamil Nadu, but many other states in this country. In fact, even internationally, sharing of river water has been a major issue. But in Karnataka, the problem between Karnataka and Tamil Nadu has been lingering for nearly 3 to 4 decades. In fact, it was more than 2 decades back that a tribunal was set up. It's now nearly 5 years since the tribunal gave its final award, but it is yet to be notified. The problem between the two states has been politicized. People have gone on agitations. There have been several problems both in Karnataka and Tamil Nadu. So today we are trying to look at how this problem of sharing of river water between Karnataka and Tamil Nadu can be depoliticized, whether it can be depoliticized at all. I have with me a very eminent panel of guests to discuss this. I have with me B.L. Shankar, a former MP and someone is also a Congress MLC now. He is someone who has an analytical mind. He has been part of the governments. He has been looking at this issue and analyzing it for a long time. I have Mr. B.V. Acharya, the former Advocate General of Karnataka. Again, someone who has been looking at this issue very closely and has been involved in many of the litigations which this issue has faced at the level of the Supreme Court. And then I have Mr. B.K. Bhattacharya, former Chief Secretary of Karnataka, another one who has had a hands-on view, hands-on approach, and also has had a very, very close view of this whole problem. And then lastly, I have Mr. K. Satyanarayana, a veteran editor. He has been in journalism for the last 5 decades. He has been watching the developments for the last 5 decades very closely. So I welcome all of them. First, let me go to Mr. Shankar. Mr. Shankar, this is a problem which has been lingering for decades, and every time, every year or almost every other year, this becomes a major political issue. You think politicians are always wait to create an issue out of it, or is it something that they have no option because both the states, the political parties, the governments in power try to take advantage of it?
No, this problem crops up when there is a shortage of water, when there is a scanty rainfall in monsoon in Karnataka, then only this problem crops up. When there is plenty of monsoon and enough monsoon, when the river is flowing full, there is no problem between Tamil Nadu and Karnataka. Yes. Scarcity comes back every 3 years or 4 years to Karnataka and Tamil Nadu. Then the problem of sharing of the water and problem of drinking water comes up. But this problem is just new. It goes back till 1924, back to 1924, when the first agreement was signed between then the presidency state of Tamil Nadu, Chennai, and then Madras and Karnataka, then Mysore state. So Karnataka feels that the agreement signed during that time, which was under British rule, both the country was under British rule, it has not done justice to Karnataka from that day onwards. Karnataka from that day onwards, it is urging before the courts, urging before the tribunals that injustice has been done to Karnataka. But unfortunately, the decision makers are either politicians or judges. Right. No technician's opinion is taken seriously, and technicians are not involved in making a decision. According to me, the basic problem, if you want to depoliticize the Cauvery issue or any river water disputes, it has to be left to the technicians, not to the either rulers or bureaucrats or the judiciary.
Okay, and that's very interesting coming from a politician who says that the issue needs to be, if it has to be, the politician should not be handling the issue. Mr. Acharya, you have been on and off handling this issue at the legal level. How serious do you think this issue is? One. Second thing is, do you think the politicians would like to let off this issue?
So, according to me, the fundamental defect is in the provisions in the Constitution and the Interstate Water Disputes Act 1956 Now the Constitution specifically says 262, the courts will have no role to play in the matter of adjudication of a dispute relating to interstate waters.
Right.
And it enables the Parliament to enact law, debarring the court from interfering with the decision or adjudicating upon the dispute.
Right.
But the fundamental flaw is in the Act of 1956, which, while saying that the courts will have no jurisdiction and the tribunal will have to adjudicate the dispute, so far as the constitution of the tribunal is concerned, it said it will be 3 judges of the Supreme Court or the Chief Justices of the High Court, and they must be sitting judges. According to me, that is the fundamental mistake. Judges may be good in resolving so many other types of disputes, but a dispute of this nature requires to be resolved only by the experts in the field. But unfortunately, the Act, instead of providing for a panel of experts, according to me, one should be an expert in agriculture, one should be an expert in irrigation. Another must be an expert in water management.
Right.
These experts can, with their experience, give a decision which will be favorable to the nation as a whole. After all, it is a very important resources.
So you don't see a role for a judiciary in this kind of tribunals at all.
At the most, because adjudicatory process is there, in the tribunal there could be one judge. It could be the presiding judge or otherwise. But essentially, according to me, the dispute has to be resolved only by experts, and that will be the best solution.
Mr. Bhattacharya, do you see this as a solution to this kind of disputes?
Well,
Dejudiciarizing. I mean, we are talking of depoliticizing. In fact, Mr. Acharya is saying dejudicialize. What a
my answer will be in the historical perspective of the way our democracy has evolved over the last how many years now? 62 years. 62 years, let us say. There is no question of depoliticization of any issue in this country, because ultimately in a parliamentary democracy, the people's representative, who are the MLAs, MPs, their representative, who are the ministers, they take final decision. They have to express the emotions of the people, they have to be alive to the aspirations of the people, they have to go to the people to seek votes, and in the process they have to make every issue somewhat political. So in this the way we have run our parliamentary democracy, I do not see any way it can be depoliticized. However, there is definitely a scope for taking the advice of the administrators, technocrats, agricultural experts, which I presume the members of the tribunal take note of, but I have not read the full judgment of the final judgment of the tribunal, so I cannot say to what extent they have been influenced by technical considerations. But I would like to mention in this connection that there is a Indus water treaty between India and Pakistan.
Right.
I was told when I attended some conference that they are the representatives of India, what is it called, irrigation commissioner or whatever it is, and the Pakistan's representative, they meet.
Right.
And in spite of the 65 war, 71 war and the subsequent tension, etc., there has never been any interruption in their meetings and discussions and sorting out issues. So, while I would appreciate what our venerable advocate, Rex Advocate General has said, that it should be left to the technocrats, experts to decide, I do not know whether it will be accepted in our country. And also, the judiciary is also very conscious about their rights, their domain in this country. Recently, I saw about the information commissioners, chief information commissioners. Court says, no, Supreme Court has said, no, this is not the way to do it. We must have Supreme Court judges, judicial members, etc. And I remember same thing arose in the case of the administrative tribunals also, that there should be judicial members, and then there should be appeal from the administrative tribunal to the high courts, etc. So it is not the way the French Conseil d'Etat, which is supposed to be our model of the administrative tribunal, they function. But every country has its own genius. We have our own genius. Our politicians will not depoliticize anything. And with due respect to the judiciary, I do not think it will be possible to bring the tribunals, etc., out of the domain of the judicial officers. But I will say that we should give greater weightage to the views of the technical experts and agricultural experts.
You have dealt, you've gone and attended several hearings in the Supreme Court, when there have been crisis situations. How much does your legal team take note of the the advice given by the technical team? How much in Karnataka has its own technical team helping this?
The legal team is 100% dependent on the technical team to present our case, because the issue involved may be legal in few areas, but in majority of the areas it is the expert's view that prevails, and the tribunal, which is constituted consisting of 3 judges, they also appoint experts as assessors and take their opinion. But what I say is, the more practical way may be for the experts themselves to be the adjudicators rather than advising the judges about the
you have watched this whole drama which has unfolded for the last 5 decades. Shankar was talking about 24 agreement. It ended in 1974. It took next 16 years for another tribunal to be appointed, and then that tribunal took another several years, 15 years or more, to give a decision. Do the politicians, how do you see the politicians seeing all this? For them, is it comfortable for them that all these problems keep lingering and it doesn't get resolved?
No. It would be very uncharitable for anyone to think that politicians want these problems. Politicians are crafty people. They can find problems where there are no problems and to carry on their politics. That is not the issue at all. The basic issue is that the 1924 agreement and subsequent events came into existence at a time when the old state of Mysore was very much weak, politically, economically, and otherwise also, influentially.
And in fact, they were not utilizing the water also.
No, we were utilizing the water. This Tamil Nadu or Madras, former Madras state. But the contribution of water to Cauvery, large areas of Malabar, which contributes a big chunk of Cauvery waters via the Kapila river, was then in the old state of Madras. So Madras included that as their share for a claim. And so was the case with Kolegal Taluk of Coimbatore district, former Coimbatore district, presently Mysore. So the point basically was this dispute would not have taken the shape it has taken today had it been roused, had it been argued upon, had it been discussed with the experts first and then taken to the judicial tribunals next. But unfortunately, neither Tamil Nadu nor Karnataka did that exercise. They straight away went and started.
Whom do you blame this
Both
for?
of them. I mean, it happened almost simultaneously. A resolution was moved in the Karnataka Legislative Assembly requesting the central government to constitute the tribunal or a de novo inquiry into the Cauvery waters dispute, and Tamil Nadu retaliated it the very next day, since both the houses were in session. So that was not so that was a fundamental mistake that for which nobody is responsible. No expert asked them to do it. Nobody in Karnataka had asked them to do it. I have not come across a single resolution of the Karnataka Pradesh Congress Committee, which was at that time the most powerful and the only representative political organization, pass a resolution on Cauvery until 1962-1963.
Okay. Anyway, you have opened up what has been the problem. We will discuss other things which has come out of this first round. But before that, we need to go into a short break. Please keep watching. We'll come back very soon and continue this very interesting discussion on Cauvery in the city of Bangalore. Welcome back. We are in the city of Bangalore discussing on the issue of Cauvery and asking the question, can it be depoliticized? Shankar, coming back to you. The mistakes made by the politicians, as Satya pointed out, in the 60s and 70s, and that seems to have, that has had a cascading effect for all these decades, the last 3, 4, 5 decades. Do you see that has the situation changed in any way as far as the politicians are concerned? Whichever party is in power, do you think that in their minds, for example, the present chief minister, some people say, doesn't belong to the South Karnataka region, so he doesn't have as much stake in this problem as chief ministers who hail from South Karnataka or around this or central Karnataka. Do you think this can make a difference?
No, I don't agree with that proposition, because anybody from Karnataka becoming a chief minister, whichever party they belong, they have to be committed to the aspirations and the emotions of the people concerned. So, and the party in power is also involved in that. There were some attempts in the previous many decades also to resolve it amicably between the states. The union government also tried. It had called many meetings of the chief minister of the concerned states, but nothing could be resolved. The problem is, it is not that there is not sufficient water in Cauvery River. There is a sufficient Cauvery river water in the Cauvery River even now in the monsoon also. The problem is storage capacity.
Right.
The storage capacity Karnataka has got, the storage capacity Tamil Nadu has got, and in the monsoon both the dams overflow and the river, lot of water goes into the sea. How to prevent it, or how to save that water which is going waste in monsoon? That is, if that problem is resolved, this can be solved amicably. There was a proposal few years back when Karnanidhi was the CM there and Jayaj Patel was the CM in Karnataka, in which I was also part of the government. There was a proposal to build a dam in Mekedatu.
Right.
And build a dam in Mekedatu to store the water and generate power for Karnataka and water for Tamil Nadu. There were some discussions, and finally Tamil Nadu didn't trust Karnataka that they will be releasing water when they are needed.
Right.
If they generate power and also they don't release the water, there was some mutual suspicion. Even today, in the there is no chairman for the tribunal now for many years, and after the tribunal gave the final award 7 years back, there are review petitions pending before the tribunal, there are appeals pending before the Supreme Court. Even now what union government can do is appoint a chairman for the tribunal and ask them to adjudicate all the pending issues before the tribunal in a time bound manner, and ask the Supreme Court not to intervene with the proceedings of the tribunal.
No, but Shankar, I have this question to you. 7 years. Karnataka has been consistently trying to stop this tribunal award from being notified. They have succeeded in it so far. You think now it has come to a head, now they had to release water this time, and there's still on 18th a delegation of Karnataka members are going to meet the Prime Minister. How wise is it to have stopped this? In fact, I would want both of you and Mr. Acharya to comment on this.
No, the only reason Karnataka
stopping the notification.
Yeah, trying to stop the final notification is because there are petitions pending before the tribunal, the review petitions pending before the tribunal, and the appeal pending before the Supreme Court. Karnataka has also not accepted the final award of the tribunal. Tamil Nadu and all the 4 states have not accepted the final award of the tribunal. They have questioned the veracity of their judgment. So, since that is adjudicated, it will be unfair if the notification is made for. Then finally, there are so many things, whole thing will go to the hands of the union government, lot of monitoring will be there, and though only one advantage Karnataka will get is that the restriction on area will go. Now the 11.25 lakh acres restriction is that will be taken off. That is the only advantage. But other issues which are pending, that it is whatever the water sharing has been given to Karnataka, we have claimed that it is unfair compared to Tamil Nadu.
Okay.
So, unless that is adjudicated,
Shankar, that is okay.
See, as Bhattacharya, as Acharya told, Supreme Court can't decide on this. Supreme Court can't say you release 2 CMC, you release 6 TMC every now and then. It is not the business of the Supreme Court to do this. They should have referred it back to the tribunal.
Let us look at it for a moment from the Tamil Nadu's point of view. Now they have to get water. Karnataka is not releasing water. So where do they go? They have what is their resort? They have to go to the Supreme Court, because the political executive seems to shift the its work onto the judiciary.
No, that itself is the main problem now. First of all, let me tell you, the Interstate Water Dispute Act specifically says you constitute a tribunal only if the negotiations between the states fail. That is why, as Mr. Shankar pointed out, there have been negotiation. But what was the type of negotiation? It was only between the two chief ministers. And then they say it has failed. All through, that was the position. No attempt was ever made by both the sides to have the different experts meet and then
Mr. Acharya,
resolve the issue.
That's fine. But
That
what Mr. Satyanarayana pointed out, he said there was never any attempt. Karnataka first went and passed a resolution to form a tribunal. Then how can you?
No. We never wanted a tribunal. We
Mr.
contended.
Satyanarayana?
No.
Mr. Satyanarayana?
See, I was the Advocate General in
Government to constitute.
I was the Advocate General in 1990.
Yes.
When, in spite of our objection, we said negotiations have not failed. Time has not come to constitute a tribunal. The Supreme Court overruled our objection and then constituted the tribunal in 1990.
Yes.
And as I said, the law specifically says it should be only sitting judges. Now, every water tribunal we have seen, every judge who is about to retire is appointed, and then
next 15 years
is a post. Yes, because the judges are interested in continuing.
Yes.
There is no anxiety, as it would have been the case if it is experts.
You're making
immediately.
as a legal man, you're making a very serious statement there.
I know, but what exactly has happened?
Exactly.
The way you have seen, 1990 tribunal is constituted, and the award is given in 2007. 17 years.
Yes.
It shouldn't take that much of
Mr.
time.
Bhattacharya, in your experience as a chief secretary, somebody who has been, is there a deliberate delay in this in this, or it suited both the states that the tribunal kept postponing? Because we have seen in Delhi that these tribunal hearings, they start, they get the next date is given, nothing much happens, it just lingers on and on and on. Who is responsible for this?
I'll make a few general observations first. I think reference was made to 1924 agreement.
Right.
Before that, there was some agreement in 1891.
Right.
1924 was supposed to be within the framework of 1891. And you also mentioned that Karnataka did not utilize the water. If I remember correctly, when Bhattacharya proposed the KRS dam in 1911, the work was stopped for 13 years because of the protest from Tamil Nadu. Work was started only in 1924 and completed in 1931.
Right.
So after that, Karnataka did not have the freedom of action to utilize the water flowing through its territory without taking approval or consent of the neighboring state. So by the time it came to 1972, when Tamil Nadu was utilizing some 20 lakh units or hectares or whatever unit of area under irrigation, Karnataka was able to utilize only about 6 lakh hectares or something.
That's a historical fact. Now nothing can be done about it.
That is true.
Now
what I say is that it is not the fault of Karnataka that they did not utilize the water in the past, and so they should be penalized in the future. The fact is that in most of the interstate water, the lower riparian state are able to utilize the water first because they are at the lower level, it is easier. Upper states, because of the terrain, etc., they do not get the opportunity to utilize in the initial stages, so they have to lag behind.
These are all well-known facts, well-known things. But Mr. Satyanarayana, what I want to find out is, now that the tribunal has given its award, within the framework of the award which the tribunal has given, can a solution be found?
Allow me to finish. The problem arises, as Mr. Acharya pointed out or Mr. Shankar pointed out earlier, only in years of distress.
Right, absolutely.
Now, in the first interim award, there was no distress formula.
Absolutely.
Here, in the final award, some
there is a distress
generalities have been mentioned about proportionate sharing of the distress, etc. Now, if water is allocated on the basis of what is known as 50% dependability, which means that in 50% of the years, water will not be available, because that is the, if you take the normal distribution of the water source and water supply and all that, you will find that 50% of the time it will be below the
average,
below 50% of the time above the average. So 50% of the time it will be distress here, and then the states will be
fighting
with each other.
No, but Mr. Satyanarayana,
some distress formula which has to be discussed, as Mr. Acharya mentioned, with the expert advice, with the statisticians' advice, with the irrigation experts' advice, how the distress should be worked out. Then probably politicians will find it easier to come to some kind of a solution.
Do you agree, within the framework of the present tribunal award, some solution can be found, so that this and it is completely left to the technocrats and people who are to be involved, and the political executive can keep itself away from this problem? Do you see such a possibility at all?
No, that can always, discussions can always solve the problem only when people agree to find the discussion, participate in the discussion.
There is this serious lack of trust, distrust of the
serious lack of willpower on the part of those powers that be in both the states to gear to serious discussion.
Yes.
All along, as it has all been pointed out, the interstate river water disputes discussions have all been a farce, and tribunal hearings, we know how it was conducted years later. Karnataka is not expected to build a storage capacity for Tamil Nadu.
No, but what is the last words quickly? So you see some sense being driven into the two sides and allowing it to be a technical issue and not a political issue. Do you see that happening at all in the near future?
That's very difficult to say what course that politics takes.
Okay.
I think actually
very quickly, sir, we are completely run out of time.
Just only one point I want to say. Now, immediately, according to me, the problem can be solved if the Supreme Court decides the SLPs filed by both state and Karnataka immediately. It is pending since more than 5 years.
Okay.
Similarly, the clarification petitions of both sides before the tribunal, appoint the chairman, get it disposed of immediately.
Okay. On that note, we have to end. This is a discussion which can go on, and in fact, this dispute has been going on for decades, and a discussion cannot be and to find a solution cannot be finished in half an hour. But all four eminent people have said that this is an issue which needs a sensible solution. There is a problem with the politicians as well as the judiciary. Hopefully something good will come out of it, and we will see that in the future years this dispute between the two states will not come to the streets. Thanks to all my guests, Mr. B.L. Shankar, B.V. Acharya, Mr. B.K. Bhattacharya and K. Satyanarayana. Please keep watching. We will come back with another issue of the big picture same time tomorrow.